Good evening and welcome to the community conversation on surveillance in the expectation of privacy, presented tonight by the ACLU Northern California Santa Cruz Chapter Police Accountability and Transparency Committee. I am Lee Brokaw, he, him, his, chair of that committee. A couple of housekeeping items. Closed caption is available by clicking on CC at the bottom of your screen. Questions can be submitted in the Q&A. Peter Gelblum, our board chair, will pass them on to our moderator after the panelists complete their presentation. If there is any time left at the end of our evening, we will open the floor for live questions. In the past, with a subject such as this, we have formed a group to continue the conversation to work on the topic locally. Please contact me for information on such an opportunity. My email address should be at the top of the Q&A. I've also placed 3 article URL links in the Q&A, which address the issue of license plate readers. And we've got a total of 78 people who have registered, and we've got not quite half of them now. But I did want to give a shout out to those folks in Chicago, Toledo, and New York City. What a surprise. Our panel moderator is Gary Patton, adjunct professor at UCSC and former 5-term Santa Cruz County supervisor. Professor Patton, it's all yours.
Well, good. I think somebody knows how to make my, there I am. Well, hello to everyone. And let me just say personally, before I introduce the panelists, which I'm planning to do, and then we're going to hear from every one of them, what a great thing it is, I think, that this conversation in our community is taking place thanks to the local committee that has put it all together. As Lee mentioned, I have been teaching a class up at UCSC for, I don't know, I think about 12 years, called Privacy, Technology, and Freedom. And the topics that are going to be addressed by the panelists tonight are absolutely central, and many people do not understand what really technology, what this really means to us. It's a pretty powerful, and it has powerful implications for our ability to maintain a democratic and free society. And so it's just exciting for me and be here, and I'm proud that Santa Cruz is taking such a leading role in this. And I'm also delighted, let me just say, to hear from some of these speakers that we're all going to hear from, because I have been reading about them for the last 12 years, many of them. They are truly leaders in the issues around privacy, technology, and freedom, and about community surveillance. So let me just introduce now quickly the panelists we're going to hear from, and then we're going to talk to Tracy Rosenberg first, but I'm going to introduce everybody before we go back to Tracy. Let me introduce Tracy now. Tracy is the executive director, and she has been since 2007, of the Media Alliance, which coordinates issues around privacy and surveillance in the East Bay, Oakland Privacy, and Bay Area Surveillance Coalition. These are the organizations with which Tracy works, and she is nationally known. And as I say, I've heard this name before myself teaching the class. She is nationally known and recognized as an expert on privacy and surveillance. And she is a longtime media watchdog. And thank you for barking on our behalf. Let me say next, joining us from the East Coast, I'm not sure I'm supposed to reveal that, but Matthew Guariglia is an activist. This is his own identification, an activist But besides being an activist, he is a senior policy analyst at the Electronic Frontier Foundation. People that are talking about surveillance and privacy issues know about the Electronic Frontier Foundation. It's a terrific organization that has had an immense impact in this area. And I am really delighted, and I think we're all going to be delighted to hear from Matthew. He is an author, besides being an activist and senior policy analyst. Recently, he has written Police and the Empire City, Race and the Origins of Modern Policing in New York. That's a 2023 book from the Duke University Press. He is co-editor of a forthcoming 50th anniversary edition of the Church Committee Report, which will be published by W.W. Norton. And he's, just look him up on the internet. He has written copiously in these issues. And as I say, the Electronic Frontier Foundation is a leading organization on issues of privacy, surveillance, and democratic freedom. Nick Hidalgo, the third panelist that I'm introducing, is a staff attorney for the Technology and Civil Liberties Program at the ACLU of Northern California. Nick works on a variety of issues, including privacy, surveillance, and free speech. And he has most recently been working, investigating privacy harms caused by government and corporate use of surveillance technologies. The technology part, he knows about that part. Cameras, automated license plate readers, which we're going to hear about, drones, artificial intelligence. Again, Nick, I'm delighted you're here. I've been teaching about these things. Here's an expert that I get to listen in on, and we're all privileged to do that. Finally, Michael J. Gennaco is the principal of the OIR group, and what he does is essentially provides services in the field of independent oversight. So he comes in and provides oversight as a monitor for negotiated agreements involving police reform. He assists federal courts in developing remedial plans intended to cure defects in constitutional policing. He conducts independent reviews of critical incidents, including officer-related shootings, and he is essentially advising and assisting both the city of Santa Cruz and the county of Santa Cruz. So he knows the local scene, besides, candidly, he knows the whole scene. And so you can see, I think everybody on the call tonight can see everybody here pictured. It is, again, just a privilege and an honor to be associated with this conversation. And let's get into the conversation right now. Tracy, you're number one on the list. Take it away.
Oh, hey everyone. Happy to be here. I'm Tracy with Oakland Privacy. Just to summarize, Oakland Privacy is a citizens coalition that advocates for safeguards and guardrails in the interest of privacy protection, civil rights, and community consent. So I've been given some pretty humongous questions here to talk a little bit about the history of mass surveillance, answer the question, is there any privacy left? And talk about how people can advocate for less surveillance. I am not going to be able to talk about all of those things in detail in the amount of time that we have, but I thought I would just sort of put out a couple of sort of broad points, and then the other experts who are lucky enough to have on this call can kind of hone in a bit and we can dig deeper. So when we talk about mass surveillance, it's important to say that surveillance and policing is and has always been fundamentally about the protection of property, physical property, and also human property. And when I say human property, I'm not just talking about slaveholding societies, although that is certainly one form that it has taken. Human property also includes all of the people who have limited autonomy in society, including minor children, people in the criminal justice system, and any ethnicity, religion, or identity that is seen at the time as subversive, different, alien, or dangerous. And it is not a coincidence that a lot of the privacy laws that you will see coming forward as proposals are focusing on the protection of children. So when we talk about mass surveillance, it can be difficult because really surveillance has two purposes, not one. The first, which is the one that you will usually hear, especially in the policing context, is to catch and potentially deter people in the act of committing certain things that we don't want them to do, which we call crimes. The second purpose, which we rarely identify clearly and often have trouble talking about, is to chill and discourage subversive behavior and to encourage societal compliance. Groups and institutions that value compliance usually love surveillance. Think homeowners association, think churches. When we have public conversations about surveillance, the first is often kind of front and center, right? We're stopping crime. But the second is kind of what we're not talking about and what lies underneath. And I would argue that by chilling subversive activities and new ideas and insisting on mass compliance, surveillance is by its nature retrogressive and needs to be understood as a method of social control. To put it in a soundbite, surveillance discourages ideas like the world is not flat, it's round. So our country has had a few sort of mass cataclysms around various kinds of surveillance. One was the Civil War, which was a particularly bloody reckoning with the owning of other human beings and the creation of wealth based on unpaid and involuntary labor. And that was largely resolved not only by the war, but by the establishment of Jim Crow as an alternate system that retained some of the benefits. Another was the violent crushing of the communist anarchist movements of the early 20th century, including the fight for unionism and the weekend and the Haymarket affair. And this was resolved largely by the establishment of the partial social democratic state and the New Deal. Then we had the social movements of the 60s and 70s and COINTELPRO. And as you may note, these sort of cataclysms happen, these moments of kind of societal conflict, and then things reform. And it's important to understand both meanings of the word reform. Yes, things change, but they also come back together in a different structure that retains some of the benefits of the previous social control system, but seems nicer. So generally, privacy has sort of taken the form, when we talk about it, of public and non-public space. So we all generally acknowledge that we do things inside our house that we would not do on a public street. But technology has increasingly confused the waters between what is a public and what is a non-public space. We feel like we're doing something private when we tap away on our computers or our phones, but in fact, we're not in a private space at all. So much surveillance and privacy litigation and regulation focuses now on electronic communication and information and sort of how privacy as an idea applies to those things. Automated license plate readers are a terrific example of this. Yes, we're out in public and anyone can observe our car and note our license number and take a picture of it. But that is different than photographing our license plate every 6 blocks, saving it, timestamping it, uploading it to a police database, and keeping it there instantly searchable for a period of months or years. That's basically like being trailed by another person or car every day, all the time, which is generally not what we expect to happen when we go out in public. So technology basically automates, speeds up, and surveils at scale otherwise what you might consider public processes, and fundamentally changes them by so doing. So how can people advocate? When I describe Oakland privacy, I always stress the community consent part, which I kind of threw on there at the end of the description. I mean, yes, privacy protections and civil rights, but community consent is really important, and it's the thing that is never in the conversation. when some new surveillance technology comes to your town, like, did anyone ask you? I mean, yes, there's a balance between safety and security. Who decides where that balance is, and can we actually say no to whatever surveillance proposal is coming down the pike from local government or the police or whoever? And I would say, is that right in statute? Can it actually be exercised, or is it hypothetical? And I would make the argument that if it isn't in statute, if it isn't a law, at least when it comes to the government, it might not actually exist factually. You can vote people out, sure, but that usually doesn't change the surveillance reality, right? You vote people out, and that doesn't mean that the license plate readers or the drones or whatever suddenly aren't there. So one of the fundamental pieces of advocacy is, if the community doesn't want it, can we say no? And if so, how do we do that? Because it's never easy, because a lot of the public wants to sort of not worry about these things and trust the people in charge, but easy and impossible are two different things. So is there a public decision-making process? And second, is the only options within that process sort of yes or no, but what about the how? Do we get to weigh in on how often, in what way, for what purpose? This is what we call policy review. Government really, really hates that part, but it's important, because sometimes the answers are not black and white, and for certain purposes, something might be acceptable, might hit that balance, and for other purposes, it might be completely crazy and out of the question, right? And so the challenge there is creating a community of sort of policy reading people that are willing to sort of make this part of their civic engagement tasks. And that is not easy. And finally, and this will be my last point, there are kind of profound issues of sort of cultural change. Certainly within the police and the government bodies, there is the idea of being that this is a consent process and a collaborative process. Probably 85% of them at this point do not believe that at all. And there's 15% that are struggling with it somewhat. That does need to change. But also within the community, we need to understand that these are decisions that we are going to empower ourselves to make communally, is what I'm trying to say. And that we need to understand the impact on everyone around us, not just ourselves, including the most subversive populations that live in our community, that we may not mix with that much, but who are impacted. And think of it as an us, not a me, because it's not just how it impacts me, it's how it impacts everyone else. And lastly, I think it's important in these conversations to keep hold of that dual purpose that I talked about. Yes, there's catching perpetrators of crimes, but there is also social control and sort of compliance. And making sure that we talk about both and don't get them confused, because what often happens is we start off talking about one, but we're really talking about the other one. And that's where sort of the history of surveillance, some of those things that I mentioned about these period of times when we've kind of had reckonings as a society, is kind of helpful, because we need to sort of, understand the role that surveillance has actually played in US history, and then we can have a more full conversation. Because the reality is, people actually like weekends a whole lot, but they don't always fully understand how it is that they came to have. So Gary, that's my spiel. And thank you for the opportunity to come and talk to you guys.
And we're going to get to ask you questions at the end, right? Let's let everyone know how this is going to go. We're going to
absolutely,
yeah, because I had a couple of questions that came up as you were talking, Tracy. So I'll think about them, and hopefully those who are in our audience who are part of this conversation will as well. Policy reading people, how we get people to read the policies, that's an important point, and I think that's one of the things you do every day from the way I'm hearing it. Well,
Indeed.
let's talk with Matthew now. Guariglia, Matthew, thank you again for the Electronic Frontier Foundation. Go for it.
Thank you. Yeah, thank you, Professor Patton, and thank you for having me on this panel. I get to have the honor of sitting on this panel with a lot of people who I've been in the metaphorical trenches with for about 5 years now, fighting against police surveillance in the Bay Area and at the country at large, which leads me to the unenviable task I have, which is I've been asked to talk a little bit about Proposition E, which was a ballot measure in San Francisco, which was on the March 5th ballot, and what happened there and what it did and what it means for all of us moving forward. And I know many of my fellow panelists were very much involved in that fight with me as well. So this builds very nicely off of Tracy's talk, because it is a question of consent and of democratic principles. I'll start with a little bit of background, and then I'll work our way to Proposition E. We'll go on a nice little journey together. So in 2019, a big coalition of groups, including ACLU Northern California, including EFF and a number of other groups, including those represented on this panel, helped to pass a CCOPS ordinance and a facial recognition ban. So CCOPS stands for Community Control Over Police Surveillance. It is a bill, I'm sure, a type of policy I'm sure many of you are familiar with. A lot of cities in the Bay Area have passed these bills now. And they change from city to city, but the one in San Francisco had very specific designations. It said that if police want to purchase a new piece of surveillance equipment, they need to publish a use policy. They need to have a public comment period so people could voice concerns. And then ultimately, it needed to go on, up for a vote on the Board of Supervisors, who would get to ultimately have their elected officials get to vote on whether or not police get to use this tech, get to buy it, get to spend public money on this kind of invasive technology. And the system worked. There were a lot of things that came up for a vote to the Board of Supervisors in the next few years that police wanted, and it was a big battle. Police wanted access, for instance, to non-city cameras. They wanted to be able to get live access to business improvement districts and consumer benefit districts, their semi-private, semi-public security cameras. And it went by the process. It went up for a vote. There was a public comment period. We had a very protracted fight. Ultimately, police got what they wanted from that system. CCOPS, it's not a perfect system. It does not always work out for privacy advocates, but what it does is it brings what is otherwise an incredibly undemocratic institution like police departments and brings it under a little bit of voter control, democratic control. Because ultimately, if a Board of Supervisors member keeps approving equipment for police and you don't like it, you can help try to oust them, for instance. And so that was the system in San Francisco after we passed this ordinance in 2019. Proposition E was part of a protracted attempt to weaken that CCOP system. And so while they decided not to bring it to the Board of Supervisors, like another piece of policy, what they decided to do is capitalize on this kind of fear crime panic that we're currently in right now, and bring it directly to voters. That maybe the voters are scared enough and they can be convinced to write the police department a blank check. And what that looks like is asking them to vote for Proposition E, which weakened this 2019 pretty outstanding CCOPS ordinance that brought community control to police surveillance. And so what it did, it did a lot of things. It weakened the oversight board. It allowed drones for police chases. It weakened the restrictions around high-speed vehicle chases by police. It changed the designation of what police force was, so that police didn't have to no longer have to fill out a use of force report just for drawing their weapon, which they did before. And finally, what it did, which is pertinent to this topic today, was it gave police 365 days, 1 year, in which they could use any police surveillance they wanted. They could contract it, they could buy it, they could test it before that CCOPS the CCOPS process would kick in. So police could buy, for instance, a predictive policing algorithm, and they could use it for 365 days, and then they would have to publish a report. They would have to have a public comment period and put it up for a vote. So it very much weakened this bill that everybody was very proud of, and that we all think was working. Became, in fact, a model for many other cities across the country. And ultimately, and we'll talk about why, Proposition E succeeded. It very much weakened oversight of police in the city of San Francisco. It won by only 8% of the vote, which we were pretty happy with, considering we were terribly, to use the awful metaphor, outgunned. The side trying to pass Proposition E raised, I think the ultimate tally was, I think, $1.6 million to promote their side of the proposition, versus the much smaller sum raised by opposition groups like ACLU Northern California. And so, and they very much, like I said, capitalized on a growing climate of crime panic in San Francisco, which has a lot to do about, feelings of safety and a lot of very high profile kind of sensationalized crime, as well as the kind of quality of life sort of infractions that people love to tie to larger feelings of safety, things like vandalism, broken glass, the old kind of broken windows theory. And this is something that is not unique to San Francisco. San Francisco obviously has its large lion's share of fear mongering. When people hear about San Francisco now, they just like think about what they saw on the news about car break-ins. But it is happening nationwide, despite the fact that statistics and FBI reports would tell us that violent crime is at an incredibly low place right now, especially where it was in 2020. That in some cities it's like never been safer. Violent crime rates are incredibly low, and yet there is this kind of growing perception that crime is out of control. There are growing feelings of unsafety, which in many cases are not unfounded. People feel unsafe for a reason, and we can talk about that in a minute. And so the question of whether or not something like a Proposition E could pass elsewhere in cities that have made big strides since 2019 and 2020 to bring their police department under Democratic control, yes, it absolutely could, and it has in many places. New Orleans, which passed a facial recognition ban, ended up revoking that facial recognition ban a few years later, amid kind of fears that the police department were not solving enough crimes. And I think they revoked their ban passed in 2020. They revoked it in 2022. And from their report in 2023, I saw that in that year, they did not make a single arrest as a result of the face recognition they got back. So these sorts of things are happening. Washington, D.C. just passed a big kind of municipal omnibus hard on crime policing bill. So these sorts of things are happening. And yet we're still having victories. ShotSpotter, which is an acoustic gunshot detection technology, which has been proven in many reports to be incredibly inaccurate, which sends armed police expecting a gunfight only to find cars backfiring and kids playing with firecrackers, putting their lives in imminent danger. And that message has been getting out. Cities who are sick of spending the money, who are not getting the results they wanted, are canceling their subscriptions. The word is kind of out on ShotSpotter and a lot of other technologies like it, which are kind of snake oil for the fearful cities, which police can sink money into. So despite the fact that we have this kind of growing crime panic, the movement that we are all a part of, it does persist, it does march forward. So how do we proceed? Well, I mean, I think community control over police surveillance, it's not a perfect system. Obviously, if you have a city council, which is incredibly prone to giving police whatever they want, CCOPS could just be one small hurdle before they rubber stamp the same blank check for police departments. But what it does do is it gives communities a chance. It gives them a chance and a little bit of transparency to understand what on earth their police departments are doing, because in most cities in America, they truly have no idea unless they happen to catch a like procurement report, or if the police send out a kind of bragging press release about this new high-tech technology they have. It's really hard for the average person in the United States to know all of this technology the police are using, how they justify it, what they're spending on it. And it's important because it's invasive, it's dangerous. As I said, a lot of this tech sends armed people expecting gunfire to situations that do not require that kind of force. It's incredibly expensive when that money could go elsewhere. And often it doesn't work. It's not effective. And why do police do this? It's because over the last 100 years, I'm a historian of policing and surveillance. Over the last 100 years, policing and surveillance is the only tool that governments can offer when people ask for safety. They ask for safety, and what they get is more policing and more surveillance. And so when people say we feel unsafe, police have to seem proactive. They want to seem like they're doing something in response to the voters. And so often what they do is they just sink their money into new technology. They say, we have heard you, we know you feel unsafe, therefore we have made these moves. We are putting up all these cameras, we're putting up gunshot detections, we put up license plate readers. And ultimately these things, they don't stop crime, they don't prevent crime. We've seen enough security camera footage of crime happening to know that people don't often see security cameras and then not commit crimes if they were intending to do so. And so the thing that we can do is we can think about how to wrest community control away from police and their blank check to buy technology. And we can think about safety holistically. When people say they feel unsafe, we can think about other things that would make them feel safe that are not punitive, that are not cameras that are going to go toward, putting mostly Black communities under a microscope and then heavily enforcing misdemeanors and quality of life crimes. We can think about lighting. Lighting is one of the things that they figured out 100 years ago makes people feel safer on the streets. We think about mixed-use zoning, because when people are walking to and from bars and restaurants at night and the streets aren't abandoned, people feel a little safer than they did when the streets are dark and desolate. So thinking about safety holistically and what else we can give people when they ask for safety that is not punitive is an important part. And it's something that we are certainly going to think about as we respond to this post-Proposition E world, in which there is clearly a kind of fear over crime, a panic about crime, and people want to know what we can give them to feel safer, and they need to know there are solutions that are not just more surveillance and more policing. So I will leave it at that.
Well, that's really a great presentation, Matthew. Thanks so much. And let me just remind everybody, I don't know, we've got 30 plus people here on this conversation. Before Nick takes the ball and runs down the field with it, let me remind you, if you got a question for Nick, or what about Matthew, or what about Tracy, or what about Mike, who's yet to appear here, go to the Q&A. It's down at the bottom of your screen. Click on that little thing that says Q&A, and then write up a question. Otherwise, I guess maybe I'm going to be asking all the questions, and maybe we'll have some of these people interact a little bit, because I hope you're getting the idea. I definitely am getting the idea that every one of these panelists really understands these issues in a deep way. And what I'm thinking is most of us in the audience portion, we don't understand it quite as deeply. And this will be a great hour and a half if we in Santa Cruz here, calling in resources from as far as the East Coast, thanks to modern technology, can start really understanding a little more thoroughly what both the problems are and also the possibilities. We heard a few little possibilities there right at the end from Matthew. Nick is with the ACLU of Northern California. He is a privacy specialist. He's going to talk now. And remember, put in those questions for all of the panelists in that Q&A box. So Nick, thanks again for being here. And I'm standing by to find out exactly what you can tell us. And then we're going to come back around after everybody's talked.
Sounds great. Thanks, Gary, and everyone involved with organizing this event. The Santa Cruz chapter of the ACLU of Northern California. I'm very grateful to be here amongst such amazing panelists. Matthew and Tracy, you've both already inspired me, and Michael, I can't wait to hear from you later. As Gary said, I am a staff attorney on the Tech and Civil Liberties team. I split my time between working on consumer privacy and government surveillance, but privacy is always front of my mind. And lately, my team has been tackling issues pertaining to novel surveillance technologies, some that we've already discussed today, like drones and license plate readers and artificial intelligence systems, and the way that AI can supercharge other forms of surveillance. But today, I'm going to be speaking to you about some of the laws that actually do protect us against government surveillance, even in those public spaces. Tracy did a really good job of explaining the problem with how technology makes traditionally public spaces, surveillance there feel like a privacy invasion, and I agree that it is. I'm going to talk a little bit about constitutional and statutory privacy protections, and then explain a little bit about the importance of local and county laws, although Matthew already did a phenomenal job of explaining how local ordinances can protect you from surveillance, and the problems when some of those protections are rolled back. So both the federal and California constitutions, thankfully, protect the right to privacy. The word privacy does not actually appear in the federal constitution, but federal privacy rights have been inferred from several other provisions of that document, most notably the Fourth Amendment, which protects our homes and persons from unreasonable searches and seizures. Now, part of what I've been asked to discuss today is the idea, the concept, the legal framework around a reasonable expectation of privacy. It's a term of phrase that actually came from a famous 1967 Fourth Amendment case before the Supreme Court called Katz versus the United States, where the court held that a government agency's eavesdropping on a person's conversation in a public telephone booth violated that person's privacy, and that person had a reasonable expectation of privacy, even though they were in a public space, albeit an enclosed one. Now, unlike the federal version, the California Constitution does contain an explicit right to privacy right at the beginning in Article 1, Section 1 of the California Constitution, which says that privacy is one of our inalienable rights. I always struggle with that word. Now, this language wasn't always in the Constitution. It was added after an immense effort by activists, civil rights groups, and privacy-minded legislators as part of a ballot initiative, and was added in 1972. This right to privacy is actually supposed to be broader than the Fourth Amendment and protects Californians from intrusion by both government and private actors, such as corporations. Now, when the right was first interpreted by the California Supreme Court, the burden was completely on the person, the party infringing on the privacy right to show a compelling interest in violating a person's right to privacy. The court did not actually require, under the California Constitution, a person to show a reasonable expectation of privacy until a 1994 case called Hill v. NCAA, which actually involved Stanford student athletes who alleged that drug tests that they were required to take as part of being student athletes violated their privacy. Unfortunately, the court incorporated that Fourth Amendment reasonable expectation of privacy requirement into the constitutional right, which had not been there before, and found that the students, by nature of their status as student athletes, should have reasonably expected that they would have had to undergo a urinalysis drug test in order to compete in college athletics. So that was a step back for the law. And now, reasonable expectation of privacy is something that plaintiffs need to prove under both state and federal constitutional law in order to assert their constitutional privacy rights. The analysis of what a reasonable expectation of privacy is very similar under both the state and federal constitution, and it's incredibly fact-specific. The courts can consider the customs, practices, social norms, and physical settings surrounding each case in order to determine whether a person seeking to exercise their constitutional privacy right has a reasonable expectation of privacy in that situation. Now, in both federal and state constitutional cases, courts have found that reasonable expectation from physical invasion or eavesdropping or tracking in traditional places like a home or other sensitive locations. And as I've already discussed in Katz v. United States, courts have also found a reasonable expectation in a public place, albeit, as I said, an enclosed one. But as I said, whether a court will find a reasonable expectation is so incredibly fact-specific that it's really hard to predict when and where such an expectation exists and can actually, and therefore your constitutional rights actually apply. And unfortunately, the courts are notoriously slow to adapt to changing circumstances, such as we've already discussed today, how these novel surveillance technologies like automated license plate readers, drones, geolocation tracking, and facial surveillance enable government to monitor details of our private lives to a level previously unimaginable. For example, traditionally, one might not think about driving around in public as a particularly private activity or one where you had a reasonable expectation of privacy. But law enforcement's new ability with automated license plate readers to automatically gather your location as you pass by various points lets them paint a disturbingly accurate picture of, where you go, who you interact with, and what you do with them. So now we have to ask, do you have a reasonable expectation of privacy against such mass collection of otherwise public information? As Tracy's already alluded to, at the ACLU of Northern California, we believe absolutely the scope and scale that technology enables changes the game completely. All of these surveillance technologies really do supercharge government and corporate abilities to gather our personal information in a really problematic way. Now, thankfully, some courts have begun to recognize the frightening tracking potential of modern technology. At the Supreme Court and in the Northern District Federal District Court of California, courts have recognized a reasonable expectation of privacy not to have your movements tracked everywhere you go. And at the Supreme Court, Justice Sonia Sotomayor has also observed that new surveillance technologies impact the privacy analysis. In a 2012 case about GPS trackers, she said, a precise, comprehensive record of a person's public movements reflects a wealth of detail about her familial, political, professional, religious, and sexual associations. And for regular people, an awareness that the government may be watching chills associational and expressive freedoms. Now, as society and its norms, practices, and expectations adapt to growing invasiveness of the growing invasiveness of technology, I believe that courts will start to recognize that we do have a reasonable expectation to be free from surveillance in its new forms. But the courts are not all there yet. Now, thankfully, as Californians, we have special protections thanks to some of our state laws. First and foremost amongst them is the California Electronic Communications Privacy Act, or CAL-ECPA, which went into effect in 2016 and was supported by a broad coalition of civil rights organizations, including many on this call, and was even supported by tech companies and law enforcement agencies. The law has been hailed as the nation's best privacy law, pretty high praise. And under that law, no California government entity can search our phones or online accounts without consent, a judge-granted warrant, or demonstrating an emergency. This law effectively protects Californians from warrantless government snooping of our digital information. California has also passed several laws addressing specific types of surveillance technologies. For example, Senate Bill 34 passed in 2015 and imposed requirements on people who operate automated license plate readers. There should be a link to an article about this in the chat, in the Q&A. One part of this law, which I will call SB 34, prevents California law enforcement agencies from sharing any license plate information with an agency in another state or with a federal agency. This provision protects the privacy rights of drivers in California by stopping their location information, which is effectively what this kind of tracking of license plates is, from being shared with agencies outside of the state, even with states who don't share California's commitment to civil rights. Now, the importance of that provision became especially clear after the Supreme Court shamefully struck down the national right to abortion, and many states have started to criminalize reproductive care. After that, many people do travel to the United States from states that have banned abortion to receive their reproductive care. And if California agencies are sharing, California law enforcement agencies are sharing driver information with states that have banned abortion, those state agencies could use that driver information to prosecute people who seek reproductive care in California. So the California law enforcement agencies in this hypothetical could be assisting in the prosecution of freedom of choice that we respect in this state. So with our partners at the Electronic Frontier Foundation, the ACLU has actually been investigating violations of this law for several years. And we found that California agencies were in fact violating this sharing provision, some even sharing with states, as we feared, that have banned abortion. We also learned that many California law enforcement agencies contracted with third-party license plate database management companies like Flock and Vigilant. You may have heard of these. And these companies make it trivially easy to share information access with other agencies. California agencies will buy the cameras and also the management software from places like Flock and Vigilant. And on these platforms, Agencies can share the driver information they've collected either individually with select other agencies, or they also, with the toggling of a single settings option, can share their entire database with every law enforcement agency in the country that also uses those services being Vigilant or FLOC. They have promoted this feature as being as effectively as easy as posting something on social media publicly rather than privacy. So it's that as simple as toggling that setting. And in essence, it made it very easy for California law enforcement agencies to intentionally or unintentionally violate this law, SB 34. Now, in part due to our advocacy and that of the Electronic Frontier Foundation, thankfully, Attorney General Bonta recently published an information bulletin confirming our interpretation of the law that it bans sharing driver information out of state. And we are continuing to engage with agencies to inform them about their legal responsibility to protect Californians' privacy, and have convinced many to stop sharing out of state in violation of the law. Now, while the Constitution and state laws can protect you from government surveillance, as Matthew's already said, local ordinances are crucial to preventing the adoption of unwanted surveillance technologies in the first place. Cities around Northern California have adopted ordinances like the one in 2019 in San Francisco, also in Berkeley and in Santa Cruz, that require law enforcement to maintain surveillance use policies and bring any requests to acquire any new surveillance technology to a public meeting and to allow citizens to learn what's going on in their communities and voice their concerns when government goes too far. And now these ordinances are crucial to informing citizens about how their governments plan to acquire and use surveillance technology, and allows them to push back. Already, we have seen activists use these ordinances to push back against expanded drone use in Fremont and the acquisition of more license plate readers in Berkeley. Now, these efforts are not always successful, but at least they're happening with some level of transparency, although often law enforcement tries to get around that. Now, in addition to these public notice type laws, some cities have also passed categorical bans on some of the most harmful types of surveillance technology, as already mentioned, facial recognition technology in particular. And the city of Santa Cruz actually became a leader in this regard in February when it passed an ordinance banning the use of facial recognition technology and predictive policing without giving the community an opportunity to weigh in, and requiring scientific evidence that the technology would not be biased or harm civil rights. It's really important, as again, already said, I know I'm a broken record here going third, but it's really important for community members to get involved to help pass ordinances like these, and then demand accountability from your governments when they seek to surveil you. At the ACLU of Northern California, we're actually working on a set of toolkit letters, drafts that you can use to fight back against invasions of your privacy rights. Those are available on our website. So in summary, the federal and state constitutions, state law and local laws all can protect you from unrestricted surveillance by law enforcement. But what a reasonable expectation of privacy means under constitutional law is slow to adapt, but I do believe it is moving in the right direction. And our team is working to defend and expand these privacy protections. And you can help by engaging with your local and state representatives, making sure they pass laws that protect your privacy and restrict the acquisition of surveillance technology, and just by engaging in your community and making sure that your values are heard. So I will stop there, but it's been great talking to you.
Well, I just can't not ask this question. Remember, everybody else, put your questions in that Q&A little box at the bottom of your screen. But Nick, when you talk about a reasonable expectation of privacy and I'm a lawyer, you were absolutely quoting the law correctly. In view of the technologies that now exist, and you mentioned a host of them, how can anybody reasonably expect that anything that they do is private? So isn't that test coming from the U.S. Supreme Court and now at the California level too, isn't that just a fallacy? Nobody should reasonably expect that they've got any privacy. I don't reasonably expect that because, our cars are spying on us now. I mean, you don't have to have license plate readers owned by a public agency. You just have to drive a Toyota and it tells somebody where you are every minute of the day. And as Tracy was telling. So how do you explain the reasonable expectation of privacy when nobody in their right mind could reasonably expect they have anything private left?
Well, I agree with you. It's not a good standard. And it was deliberately left out of the constitutional right in California. The California ballot initiative was in 72. And the standard was adopted into the Fourth Amendment doctrine in '67. So, and they were really smart attorneys and activists who were working on this right in California, and it was not supposed to be a part of our constitutional right. You weren't supposed to have to prove that. The burden was supposed to be on the person, the party that's infringing on your rights. It's not great. I'll be honest with you. It puts the burden on the person who's interested in their privacy to take all these actions to prove that under the circumstances, it was reasonable for me to expect that I wasn't being snooped on, I wasn't being tracked. But as you say, and as I'm sure most of these panelists will agree, the technology that exists today really just makes it very tough to make that argument. And courts have been very slow to recognize when that threshold has actually been crossed. And it really takes proving that you were surveilled time and time again, not just once, and that it was in some sort of invasive or sensitive way. And we don't think that that should necessarily be the standard. So part of my work right now is actually thinking of how we can strengthen the California constitutional right to privacy in a way that calls out that this wasn't supposed to be in the law in the first place until a frankly very conservative panel. It was the entire court, but in the 1994 case that I mentioned, involving the Stanford student athletes, it was decided by a very, very conservative Supreme Court, and that's not the court we have today. So I do have cause for optimism, but I will not lie to you and say that the law is great, but we're hoping it will change.
Okay, well, thank you so much. And we're going now to hear from Mike Gennaco, who is, let me just read his official titles relating to Santa Cruz County: Independent Police Auditor for the City of Santa Cruz and Office of Inspector General for Santa Cruz County Sheriff's Office. And I'm hoping Michael will really bring it all back home here. I think maybe that's why you're batting cleanup, because we're Santa Cruz people and we are concerned about these issues. The people on the conversation, and all of you, and the people like me who are listening in. So Mike, take it away, and thanks so much again for being here.
Well, thank you, Gary. It's great to be part of this conversation. I really appreciate having had a chance to hear the opening remarks of our co-panelists, and really appreciate the opportunity to engage in this discussion. I've been doing this for a while, and I can certainly speak to, what's going on in the county and the city of Santa Cruz, although you who live there are very close to it as well. But from a auditor or monitor or IG perspective, I can certainly talk about what we've been doing. What I would like to maybe start with, though, is just to talk about how things have changed with regard to involvement, engagement, and impact or influence on police activities and the way in which police do business in this country. When I first got started as a prosecutor, when I first got started in oversight, and even before that, when I was in high school and college years, I think that there was extreme deference provided to police to make up their own rules, to make their own decisions without any community input into how they were going to perform their basic public safety function, to make their own decisions about what equipment they were going to buy, to make their own decisions about how they would use the equipment, to make their own decisions about how they would engage with their community in, quote, fighting crime. And elected officials, and in large part the community, gave a lot of deference to police throughout the country with regard to making those decisions. I think that has changed. I think the George Floyd murder has really escalated the interest in engagement by the community in how police do its work. And I'm a fan of that. I really think it is important that this important critical public safety function and the way in which that function is performed to keep us safe does have community involvement, engagement, etc. I have to say it comes at a risk because of our democratic environment. And, I think Matthew, for example, talked about what just happened with regard to the San Francisco voters, or at least the majority of them, relating to Measure E. So as pendulum swings back and forth, with more concern about, quote, crime and less concern about rights of individuals, I think that can ebb and flow over time. And so it's an imperfect system we have. It's a democracy in the same way that there can be effective guardrails put on police activity. There can also be retrenchment of those guardrails if you can convince voters to change it. I also appreciated the discussion about the Fourth Amendment and how that impacts on the way in which we look at surveillance technology. And, thinking of the Fourth Amendment, it's largely an undemocratic provision that was put into our Constitution several hundred years ago by our founding fathers. But it really, gains, I think, prominence and influence and impact on policing in the 60s during the Warren Court, where justices of the Supreme Court interpreted the Fourth, the First, the Fifth, the Sixth, the Eighth Amendment in a way in which, greater rights were provided. But that didn't come out of democracy. That came out of a court that was appointed who came up with interpretations of these amendments in a way that benefited the rights of us as individuals, as opposed to the police state. The problem, of course, with well, let me put it this way as sort of a hypothetical. I often think, what if legislators were able to put the proscriptions of the Fourth or Fifth, you name it, Sixth Amendment, First Amendment, to a vote in many of our red states or in our red parts of California? Do you think that all of those provisions and protections would survive that kind of vote? And I would worry and suggest that at least in some of those states, it would not. So in some ways, I love, the way the Fourth Amendment has been interpreted over the years. There has been some retrenchment of those amendments. And of course, as with any constitutional provision, it's subjected to the whims and decisions and influence of the Supreme Court. And we just saw what happened in the Dobbs decision as a concerning tale about the implications of relying on court-interpreted laws to provide us protections. I would also suggest that the surveillance issues, different folks, I think thoughtfully have different positions on how surveillance should be considered. So there are, I think, if you look at the spectrum, there are some on this side that would say public safety is paramount. We should not hamstring the police. And I hear this from folks in the police business all the time, that these are effective ways to fight crime, and we shouldn't do anything to limit the ability of police to do their job, which is to provide public safety. On the other hand, we have the absolutists on the other side who say, even if it isn't an intrusion on the Fourth Amendment, and many of these surveillance techniques have been found not to be implicate the Fourth Amendment directly, that we shouldn't do it, and we should try to convince our leadership and our engagement in a way in which we will put limits on its use. And we want to do absolute bans on, for example, use of AOPRs, put absolute bans on facial recognition technology, or et cetera. And then there's a group in the middle. Well, there's a whole big group that doesn't really understand or doesn't really seem to be engaged. But then there's another group in the middle that suggests that instead of deciding all of this surveillance bad, let's stop the use of surveillance. Let's look at what it is about surveillance techniques that are concerning or problematic and try to work on those issues. So for example, in the automated license plate reader discussion, what I hear from those who do not like the system are the concerns about keeping that data indefinitely, not giving those who have been surveilled the opportunity to learn whether they've been surveilled, sharing that information with out-of-state individuals or other agencies who may abuse the information in a way that the local agency may not be. And so if those are the concerns, instead of banning that whole surveillance, do we develop guardrails that will eliminate the downsides or the potential repercussions of using that technology? And so some surveillance ordinances, some surveillance policies have looked at the concerns and tried to address those by putting guardrails on those concerns rather than taking out entirely surveillance technology that does not directly implicate the Fourth Amendment. The same can be true with facial recognition, for example. Facial recognition has been found repeatedly by studies to result in false positives, particularly with regard to individuals of color, probably because of the way the FR has been programmed. And I understand that and I get that. And I think a lot of people do, and I think a majority of people would get that. On the other hand, if you are going to be consistent, do you then say, we don't like the fact that, I think there's been changing stats, but numbers of maybe 20, 25, 30% of those who tried to rebel against our country on January 6th were identified through a facial recognition technology in part. And whether we say, well, we still got to protect those individuals and that should not have been used in that situation. I don't know the answer to that. That's a question, obviously, for discussion. But then there are, I'm just trying to point out some of the nuances here. The other thing that I think is important to recognize in deciding, where to place the parameters with regard to all of these surveillance technologies is whether this technology is substituting for more offensive types of intrusions on our liberty. And what am I talking about? So, for example, I know of agencies that have been concerned, and I know the public has been concerned, I've been concerned for a long time, about the use of canines to apprehend individuals and the implications that come from that approach. Virtually every agency in California has the ability to use canines to apprehend subjects, but it results in wrong people being bit, in lots of injuries, people, having concerns about that technique. And so what if drones are going to be used and employed instead of dogs? Is that a trade-off that we want to consider in making a decision about it? Or do we just say, no, we don't like drones and we don't like dogs either, and neither should be used as far as advancing public safety? So I think there's that. The last thing that I want to cover, at least in my initial remarks, have to do with once rules are developed either through an ordinance or through policy or through any other kind of mechanism, I think it really is important to ensure that police agencies are following those rules. And my biggest concern, and I think where I play an important role, is to ensure that once rules are in place, that they are appropriately followed, that they are enforced, that there are repercussions or consequences when those rules are violated, and that there's a level of transparency provided to the public about how that's working. And I think that my experience has been in virtually every jurisdiction in the state that has no level of oversight, and that's the majority of jurisdictions in the state of California, unfortunately, that information isn't available. Nor is there any outside entity that is really able to effectively ensure that any policy, ordinance, or expectation of a police agent is being followed internally. You can find that information out sort of by happenstance. There's always litigation, there's PRA, there's other ways to do it. But in my view, unless you have somebody on the ground day to day to day to ensure that those policies, those ordinances are being followed, you're going to find slippage, you're going to find lack of enforcement, and you're going to find workarounds that may not technically be outside the policy, but are essentially against the whole intent, spirit of that policy. The other thing that we can do as IGs or IPAs and oversight in general is to work with departments to ensure that those policies or ordinances are going to be enforceable. So, you know, may, shall instead of may, and those kinds of wordsmithing, I think is really important to ensure that agencies are following their rules and that those who don't are held accountable for failing to do so, and then telling the public whether they are doing so. So I will end my opening remarks at this point, but look forward to the Q&A and the rest of this discussion. So back to you, Gary.
Michael, thank you very much. And we did actually get a question coming in from the public, which it seems to me I want to give it out to you and then take it one step further based on your last remarks here. Here was the question: can well-written local police policies take the place of an ordinance for transparency and accountability? And maybe in responding to that, so do we really need to have the Board of Supervisors, the City Council legislate, or could we just have some policies really adopted? And you were sort of getting at, whichever way it was, you got to have a mechanism that makes sure they're going to be followed. So could you maybe just expand on that, and then we can get into the questions that, and it looks like Tracy may want to answer that too. See if you can react to that, because I think that's sort of your job, isn't it? That's what you do.
It is. I don't think that the crux is whether or not it's in policy or an ordinance. I've seen it work effectively both ways. If it's in policy, and you're a former legislator, Gary, you know, if it's in policy, it's a lot easier to change than if it's an ordinance, which then has to go through all of the legislative acts that require that. So you can be more nimble with policy than you can, I think, with an ordinance. On the other hand, the ordinance is a more permanent, if you will, assertion by the leadership of a county or a city that this is what we want you to do. So I think that there are pros and cons, but I think either work. But I think the key that you hit on is you need to have somebody ensuring that those policies or the provisions of the ordinance are being followed, and you need to tell the public what's going on.
Okay. Now, Tracy, did you want to speak to this issue too?
Yeah, I just wanted to dip my toes in. I'll be fast. First, Michael is 100% correct about the important role of oversight. If there's no oversight, it doesn't matter whether you have ordinances, policies, constitutions, whatever. It's a crucial role. And the fact that we have so little of it when it comes to our law enforcement agencies is a huge problem. What I would say is that if we get things in statute, as it were, as an ordinance, it's important that that can't just be overturned when the particular politicians in particular seats flip over. And that happens and things change. So if you are fighting for something, what you generally want to fight for is having a permanent right enshrined. And as we've seen with Prop E, even if it's an ordinance, it may not be permanent, but it is a much more difficult process to change it and a larger scale process. Resolutions can flip on a dime. And nimbleness can be good, but when you're talking about rights for the community, nimbleness may not be the primary thing that you want to have in place. And I also wanted to say that one other characteristic of these ordinances, because it's not just about memorializing community input, it is also about after purchase reporting. Most of these ordinances include annual reports like what'd you do, how did it work, how much did it cost, what outcomes were there, and it tries to at least make a sort of cost to benefit argument, like, okay, we spent $3 million, what did we get in exchange? How many people did we arrest? What happened to our crime rates? Like, did this actually work, or did we just do this and nothing really happened and there's no output? And I think those are important questions, and it's an important part of the ordinance to kind of mention, because it does strive to create a more transparent conversation that is easier for the public to engage in than if nobody tells them how the equipment is working.
And in fact, though, don't you actually need members of the public to continue to care about it and to be essentially bugging the system, whatever the exact system is, on a
For
periodic
sure.
basis? And that's sort of what you do in your real life, right?
Yeah, and I can't do it for every city in California all the time. So
No,
yes, and we need more.
well, that's why we have this committee that's sponsoring the conversation this evening. And of course, Matthew hit on exactly the point you were talking about, how an ordinance can quickly be overturned. And that was really the burden of what he said. Anybody, either Matthew or Nick, do you have any further comments on this sort of oversight once you have a policy in place issue?
I just want to reemphasize that enforceability is key, you know, whether that's a private right to action or some kind of ability for the public to get involved and make sure that their governments are following the ordinances or the policies that they pass. That's really what's important. But yeah, it's pretty much just plus oneing what Michael and Tracy have said.
Okay, so how about this is a huge philosophical question, which is, if we're talking about the public having to keep their eye on the ball and care about this and follow up and have a mechanism for doing that, or otherwise it'll just slip away. How do you deal with this question? There really isn't any need for, from a personal perspective. I mean, people say, I don't care about surveillance because I never do anything wrong, and this will only affect the bad guys. Who can speak to that?
I can definitely speak to that. I mean, the fact of the matter is that, I mean, there are a few different, I think, equally important ways of answering this question. One is that you truly don't know yet what you have to hide. First of all, you know, the average person commits crimes every day that they probably don't even know are crimes. They stop a little too short at a red light, litter, jaywalking, all of these things that when you put any community under a microscope, those things become hyper enforced. It just happens to be that in our society, only some communities are under that microscope. And so the idea is, one, that, you know, if you're saying you have nothing to hide, the fact is you probably are in a fairly privileged position where you don't know the corrosive impact that a hyper vigilant surveillance system in your neighborhood could have. The other thing is, you know, we live in a society where laws change, that things that are legal, perfectly legal now, might not be, that political opinions which are perfectly acceptable to have might not be in a few years. And all of these things are very much rooted in history. I mean, we've seen such a thing with abortion. I mean, we have a presidential candidate who has threatened to do retroactive prosecutions of abortions that happened when it was legal. And if you think that data isn't out there and isn't accessible to law enforcement, it certainly is. I mean, I don't think it's far-fetched to imagine a world in which, you know, a lot of people have been purchasing marijuana legally in many states for years, in which suddenly something might happen at a federal level and that gets turned on its head. You know, like, you know, you really don't know what you have to hide. certainly it was quite popular. It was quite chic to be a communist in the 1930s. And it was only in the late 1940s, 1950s that suddenly having a paper trail leading you to that political opinion had extreme ramifications for a person's life. So the first thing I'll say is, some neighborhoods are already under microscopes and feeling that hurt. Two, you don't know what you have to hide. And three is that, I think we need to get real about what surveillance does for safety and what it doesn't do. I think, when we ask people, what does surveillance do? Police will often say, well, it will prevent crime. We put up cameras here, theft here will stop. But when it doesn't, when we just have video of crime, what police say, well, now we have evidence, right? Now we can use this to build cases. And the hardest question then is to say, okay, if you put the next 3, 4, 5 shoplifters in prison because we have that footage and we have evidence, what does that do for crime rates? What does that do for the city? Those 5 people are behind bars. Is the city any safer? Are crime rates dropping? Is it dropping statewide? Is it dropping nationwide? And so then we have to ask more holistic questions about what causes crime, and that's a harder question to have. And it's a lot easier to slap up a camera, but we've reached the point where, people have been doubling and tripling the amount of money they put into surveillance at police departments, hoping that eventually we'll hit the magic number and crime will disappear, and it hasn't happened in 100 years. So I think I enjoy getting into these philosophical questions about like the real value and harms of surveillance, because it's something we don't think about all the time. But it's a very important conversation.
So any other comments or responses on that topic, which to me is a pretty central question, and it's a pretty important topic.
Yeah.
I will,
Sorry, go ahead, Tracy.
no, it's fast. I will just say the 2 examples I was going to cite when I was going to answer that question were Roe v. Wade and Joe McCarthy. So there you go.
And you can think of many more. I mean, think about like diversity, equity, and inclusion work in Florida. Like the laws change very quickly, unfortunately, and then slowly when you want them to. But one thing I wanted to touch back on is, Gary, you mentioned or sort of implied that it's tough to convince people to care about their privacy, about the fact that they're being surveilled. And Matthew mentioned this, touched on this too, right? It's sort of like an insurance policy, right? Like you don't think about it until you need it, until your security, your privacy is violated. And then you realize like, oh, all this information is already out there. But the problem is it's already out there. Like we need to be proactive about it. But the burden shouldn't be on us. It shouldn't be on the individuals to review, line by line, all these legal like privacy policies when we're talking about, corporate surveillance, which like I'm an attorney, I've been practicing for a decade. I cannot understand most of them. Or getting deep into Prop E to even understand what harm that did. Took a lot of work. And the best privacy laws put the burden on the party that's, like, as I mentioned in my brief discussion, put the burden on the party that's violating the privacy, like Cal ECBA, where you don't have to prove that you have a privacy interest in your cell phone or your email address. It is just assumed, and the law enforcement agency has to be the one to go and prove that they need access to that information. So the burden needs to be on the party violating the privacy because it's too hard to keep up with and protect yourself constantly. It's almost impossible.
So Matthew, do you have a comment on this?
Yeah, just one final thing, which is, to build on what Nick just very eloquently said, and to go back to Tracy's all important comment from the beginning about consent, that it's very much about trust. I mean, the bottom line is if we trusted the government to not misuse the data, to not harass people, then we would feel a lot better about, more comfortable with all this surveillance out. But the truth is that we have lived in this society for long enough. We've seen, a century of evidence that often this information is misused, that a lot of the policing is done in a racially biased way. It's done along gendered lines and class lines and sexuality, lines of sexuality. So we've seen how this data and this surveillance gets misused. And I think if we trusted the government, just as if we trusted Amazon more, where we trusted Facebook more, we'd feel more comfortable with them hoarding and collecting all this data. But the truth is that they've burned the public far too many times. Mass surveillance has happened, mass incarceration has happened, and so I think the question of consent and trust is far out the window at this point.
Wow. Well, you mentioned sort of privately acquired data. And as I'm sure you know, and maybe everybody knows, but perhaps some people in the conversation that aren't pictured on the screen here don't know that private companies are just amalgamating massive amounts of information on every one of us. I mean, from all sorts of different sources. That kind of privately, I mean, I suppose police departments can get access to that, can't they? So what's our protection for that? What's our protection of just, maybe we've got control at the local city council or the board of supervisors, and you really have a good ordinance, as Matthew was talking about up in San Francisco prior to Measure E, really was pretty damn effective. And going back to Tracy's point of policy reading people, you have members in the public who actually care about this, are focused on it, follow up on it, stick with it year after year, fund organizations that are doing it, that somehow we're on top of all of this. But then there's this mass of private data, and I alluded to cars, that's a new source of it, but any social media, massive amounts of data. Is there any solution? I mean, I guess this California law is the best we got. Yeah,
I mean,
go ahead.
There's no easy solution. There's no perfect law. There are some good ones. I didn't mention this earlier, but there's in California, there's the California Consumer Protection Act, which lets you at least obtain information about what private companies have about you. Cal-ECBA can help prevent law enforcement agencies from getting access to that data, but it's still held, that information about you is still held by private corporations who do God knows what with it. I mean, most often they use it to sell advertisements, right? I mean, your information is money to most of the corporations that we're alluding to here, the Metas, the Amazons. So there's no silver bullet, right? You have to be vigilant, and we need better privacy laws. And as I said, privacy laws that put the burden on the party collecting our information and the party who wants to use it and often misuse it. Because it can just seem really daunting to try and fight all these issues by yourself. I'm relatively new to this space. I've only been practicing in this area for about 2 years now, and yeah, it's a lot. There's a lot to try to wrap your head around.
Yeah. So, Mike mentioned guardrails, that some of these new technologies that penetrate our privacy. I mean, you just think about a license plate reader, which hopefully the people in the audience know what these things are. They're pieces of technology that just collect a picture, basically, which then is an identifier of every car that goes by wherever they're using them. Sometimes they're on police cars driving around, and it's all kept forever, basically, or for a long, long time. What kind of guardrails would maybe protect the public from a misuse of this information? We should, have a reason for search and seizure. You got to have an affidavit. The judge has got to say it's okay, that you really need the evidence and so forth. But I'm not sure that's how this is actually being used. I mean, it seems to me it's just too easy. And, in a certain point, boy, the fact that that X car was headed out of town on Ocean Street at such and such a time allows you to stop somebody up by Scotts Valley. This is a local thing for those who are out of town, but people in Santa Cruz will know what I'm talking about. Somebody's driving out of town, getting onto Highway 17, heading over into the East Bay or the Silicon Valley, but it's some father who has stolen his or her daughter away from the mother who has official court custody and is escaping and may disappear forever. And, you know, if soon as the mother knows that the daughter is gone, she phones up the police and says, my husband's taken my baby. He shouldn't do it. I'm afraid what's going to happen. And the police say, okay. And they look him up and they know what the license is. And they say, oh, well, he's just going out of town on Ocean Street. We'll stop him in Scotts Valley and we'll ask him what's going on. And if your daughter's in there and he shouldn't have them, don't worry about it. I mean, that's a pretty good piece of technology. I think kidnappings, it's been used sometimes, these license plate readers. But what kind of guardrails prevent people from, Nick, do you have a kind of a reaction to this?
Well, I'll say that the specific scenario you just outlined, like, is an example of this technology being relatively helpful, but the statistics don't back up that that's how they're used. I mean, they, you know, I think Matthew and Tracy have both cited statistics. There is not concrete evidence that these are actually helpful technologies. There are ways that you could establish guardrails that would narrow the use cases of these technologies to be the more helpful types of situations like you've identified. You know, not retaining the information very long, because in the fact pattern you just described, it sounds like it would have been useful immediately, but if it was retained for much longer, you know, who knows what it could be used for. And keep in mind that, as we alluded to, these are dragnet surveillance technologies. They're not targeted. They capture information about everyone who passes by them, regardless of whether they're under suspicion of any kind of wrongdoing. So eliminating the information as soon as it's not, has no usefulness, is a start. Limiting the use that you can put this information to is helpful. But you know, the surveillance industry will find examples wherein all of these incredibly harmful technologies can do something good. But the benefit is very rarely, and frankly, never worth the cost to privacy on the whole. You know, as we've discussed, you know, these technologies are put in Black and brown communities that are constantly over surveilled and over policed. And that just like increases their policing, right? Like it's just bias building on bias and reinforcing that bias. And most of them don't really work. Now, so there's a long-winded way of saying, this particular scenario you described, yes, that is good. I'm glad this hypothetical parent could be reunited with their child, but the statistics don't support that this is how it like usually works.
Tracy, you have a thought?
Yeah, I mean, there's a couple of basic kinds of safeguards that sort of apply. I don't want to say technology neutral, but across a bunch of the technologies. And that includes, as Nick had said, how long are you keeping it? Where are you keeping it? Is it secure? Who has access to it? Who are you sharing it with? There's a principle, what purposes can it be used for? And are there any prohibited purposes? You can do this. You can use it in the event of a kidnapping, but you can't use it for X, for example, or you can only use it in the event of a kidnapping or homicide or this or that. So these kinds of rules can be set up, and that's what we're talking about when we're talking about policy, with the note about, you know, enforcement kind of matters here. And one of the primary principles that comes up a lot is what we call data minimization, which means if you collect something from people, use it for the purpose for which you collected it, and not necessarily for 87 other collateral things that you just figured out that you could kind of do just because you had it sitting around. And data minimization also says when you've used it for the purpose intended, you don't need it anymore. So these are some of the ways that, you know, you can potentially get safeguards into policies, and maybe they'll be followed. We can only hope, or we can hire Michael to make sure. The last thing that I'll say is we talked a bit about public-private, and I just want to say every one of these, you know, police or government surveillance tech comes with a private company. That private company almost always has some level of access to the data. So putting a wall up between public and private, like, not really. It's always entangled, and it's always sort of a public-private conversation. And I think we're going to talk at some point about Amazon Ring, and that's like the perfect example of that kind of tangled weave of public and private surveillance, because I don't even know which one it is at this point. You know, it's both. and the same. And I think that's going to become increasingly true with a lot of others.
Well, let me just say for the audience and the benefit of the audience, I think we've reached the end of what was the official time, but we've got a couple of questions left. And if Matthew can stay awake there on the East Coast a little bit, you don't look like you're tired. We'll just take up another couple of questions or so to make sure that we respond to the audience inquiries. And you mentioned the Ring, Amazon Ring. I'm not sure everybody knows what that is, but essentially you can buy a doorbell called the Ring doorbell. I guess you can ring it, but it has a camera there. And for a long period of time, and I don't know, Michael, whether you know whether this is still true, either locally or somewhere else, where you're an advisor and a sort of a surveillance expert. The police would just ask Amazon for all of the footage of people passing by, coming up to their house and so forth. Let's see what people think. Michael, let's start with you, but this Ring concept where every home becomes a surveillance camera or an opportunity to surveil people walking by with their dogs or getting in their cars across the street and so forth. You have any thoughts about that?
Yes, I think, I do. I think that the Ring example is a perfect example of how the proliferation of surveillance in the private sector has increased the ability of policing to use that information sort of in an unregulated, unrestricted way until recently. And I do think that's an example. It's interesting how private industries have sort of developed relationships with public safety or other public entities in this way. You have that where, at least initially, Amazon was extremely interested in cooperating with local police with regard to sharing this information because it fit in with their marketing strategy, right, of safety. On the other hand, Apple has been adamant in putting up walls with regard to policing, with regard to getting into their iPhones, because their marketing strategy is different. And the whole idea that they want to protect the privacy of those who buy iPhones has a different feel to it. So it's kind of like, one of the things you have to look at is to see what kind of partnerships or adversarial relationships are developed between public and private.
Yeah, that's for sure. Matthew.
Yeah, I think that's absolutely right. That a lot of this is about marketing. So Ring's original system was if police were interested in getting footage, they had a portal for law enforcement if they joined this kind of Ring law enforcement partnership. And what they could do was click and draw a little square on a map, and instantaneously, every single Ring user within that square would get an email in their inbox saying, "Hello, this is Detective so-and-so. Please send me your footage between this hour and this hour." And what Ring was doing as a company was facilitating police access to their users. And there was an absolute economic incentive for them to do this. Until 2019, there were actual economic incentives for officers to go to victims of crimes and ask them to buy Ring cameras. Officers had individual discount codes that they would get perks from if people had used their discount code to buy a Ring camera. So they had a incentive to go to victims of crimes or to just knock on doors and ask people to buy cameras. And so people did not know whether or not this trusted public authority was looking out for their best interest, or they wanted the points that they were going to get to eventually cash in for free devices. And I think this is a rise of a much bigger problem that Ring was specifically emblematic of, which is the cozy relationship between technology marketing departments and law enforcement. Ring, underwent a years of incredible pushback from civil society and from activist groups, including ACLU and EFF and all these other great groups, And eventually they made a lot of concessions. And what the system they have now is they are no longer in the business of facilitating law enforcement to reaching out directly to the customers. So now if police want to get footage, they have to knock on somebody's door and ask them for it. Ring will not facilitate that request. And yet, they still have the exigency portal. So in the matter of life or death, as determined by law enforcement and by Ring, there is still a form they could fill out to get footage from somebody's doorbell without informing the Ring owner and without a warrant. So there are still ways in which law enforcement can get backdoors into your consumer technology. And I think beyond Ring, whether it's a smart doorbell or your smart refrigerator or your car, thinking about the warrant requirements that these companies might or might not ask police for is incredibly important. I mean, some of these companies will say, listen, if we get a request for 14 hours of footage, that's not specific enough. We're going to push back. We have the legal might to do so, which not every company does. And so thinking about whether or not your consumer electronic devices, the companies, would push back on an overly broad warrant, whether they require a warrant at all, whether they would inform you if they got a warrant, are all questions we need to ask now about every single device in our homes.
Wow. So Tracy, have you dealt with Ring?
Sure. Oakland Privacy did a study a couple years ago, a small one, but it was basically about a part of Ring we didn't really talk about so much, which is what they call the Neighbors app, which is something that comes to you with your Ring camera. And it's basically, I guess, security camera social media is the best description I can come up with for it. But it's a place for people to share and exchange snippets of video from their doorbell cameras. And what we were trying to kind of study is, well, when people post this video, they usually post it and say, oh, this crime was happening. This scary person was on my doorstep trying to do something bad. Like, how many times was the video that they showed actually evidence of any sort of crime? Or were we just talking about what is referred to as kind of stranger danger, which is this person looks like they don't fit in with my neighborhood and they make me uncomfortable? Right. And what the study showed is that more than, I believe it was 68% of the time, the description that comes with the video refers to something that isn't actually in the video. In other words, it implies, look at this person trying to steal the package from my mailbox. And there's no evidence in the video the person is stealing a package from their mailbox whatsoever. So it creates, very much like Nextdoor, which is sort of turned into true crime social media as well, a sensation that we are less safe than perhaps we actually are. And you sort of see the police enthusiasm for this technology in creating that environment where we need more and more and more surveillance and more and more money for police, and the ways that we can kind of artificially or culturally help to create that, whether the crime rates are actually going up or going down. And I think that's an interesting phenomenon and something to kind of talk about, because when we're talking about people want to feel safe, of course they do. But like, why do they feel unsafe? What are the things that are causing them to feel this way? And which of them are real? And which of them are what you would call, I guess, a manipulation or a cultural phenomenon that may not actually have anything to do with their actual physical safety? And we certainly need to talk about this stuff as a community, because otherwise it's really easy to manipulate us. And we will sometimes see that that is happening. And then we end up with 80% of the municipal budget going to police and no money for schools and no money for libraries and no money for parks and no money for all of the things that make life worth living.
Well, I'm going to let everybody, if they'd like to, you're not required to do it, but if anybody would like to just make a little brief sort of summary statement here. And I want to make mine first to just give you a model to think about. I'm going to go back right to the very start, and I've repeated this now a couple of times because it struck me. Tracy's calling for policy reading people. And what that meant to me was the public would understand and be concerned about and focused on these issues of privacy, policing, surveillance, freedom in our local communities, public safety, and understand that topic in an integrated way and in enough detail that they would then be able to be the kind of citizens that Michael is really calling for, that are paying attention to what's going on in their community and are monitoring it and making it a good community to live in. And it seems to me that maybe what we, and so I'm going to say, I think this would be good. And then when you sum up, you can react to this if you want to, or you can react to anything else. Maybe what we really need in almost every local community is something like Oakland Privacy, a group of concerned citizens that knows about these topics, that will sponsor local programs from time to time so that people that aren't in their particular group will find out about it, and who cares. And that if we as citizens don't have mechanisms in which we can officially get involved in the policies that make such a difference to us, we are going to end up with problems. We're just going to end up with problems. We're going to think things are good, and they're not going to be good. They're actually going to be bad. And we need everyone on the call that's still here in the conversation, and all of us in our local communities, to get involved in issues that we care about, and these issues of privacy and how technology affects that, and the kind of freedom we have, and the kind of abuses and that are possible, and how to stop them, and how to work with local law enforcement, because law enforcement is our friends. I mean, they're keeping us safe. We want them to do that. We don't want them to be a police state. And so public involvement is my pitch as I'm winding up my participation here tonight. Michael, do you have any final kind of comments or summaries you'd like to make?
Thank you, Gary. I would just reiterate that I do think that these discussions are important. The engagement, I think, is critical. I think every jurisdiction ought to set its own expectations of law enforcement in hopefully conversations with law enforcement rather than having it foisted upon them, because I think that's more effective if it works out that way. But I also do think that it's really critical to have a component of that to ensure that whatever those expectations or rules are, that there is an independent individual or group of individuals that can report out how whether or not those rules are being followed, and if not, what the implications are for that. So in Santa Cruz, the city has had oversight for quite a number of years. I think it's become more transparent since I took over with public reporting. I'll be there on Tuesday to report most recently on what we found over the past year in a public session before council. And we'll be doing the same in the summer for the first time on the county side, Gary. So those public reporting, I think, are key and an important component of ensuring that we're all on the same page here.
Nick, you have any final overview?
I always have plenty of thoughts. Yeah, look, technology is supposed to make people's lives better, okay? But surveillance technology tends to be like a knee-jerk reaction of policymakers that are looking for quick fixes to really complicated issues like safety and housing. Those instincts are then reinforced by the surveillance technology industry that is trying to make a profit off of these technologies. And then also by the police, who are often enmeshed and have deep relationships with the industry, and are trying to look like trying to increase their surveillance capabilities to help reassure people. This happens even though there's very little evidence that these technologies actually help address these problems. And now, as I discussed today, like there are a lot of really solid laws that can help protect your privacy. And as Californians, we're actually privileged because we have stronger privacy laws than most. Also, as I've said, the burden should not be on the individuals. It should be on the person who's violating the privacy. but that's, that's an optimistic view of what the future could be. Right now, we need engagement, as everyone is saying here. Community involvement is key. We need an Oakland privacy everywhere. We also need ACLU chapters like the Santa Cruz chapter to continue to host events like this and to continue to be involved and push back against needless surveillance. The people do have power, even if we shouldn't have to wield it this way and be as vigilant as we have to be right now. We do have that power. And so, yeah, I encourage everyone to get involved in all of our various organizations and yeah, just pay attention to what government is doing and what corporations are doing too, and how they work together. Yeah, there are ways to make to protect our rights, and you don't have to be an ACLU attorney to do it. Yeah, so we need people like everyone who's panelists, the moderators, and also the people who are participating in the chat. So thank you very much for having me. It's been a pleasure speaking with everyone.
Thank you. And Matthew, you were nodding your head. You have something to say?
No, I agree with everything Nick just said. I mean, I think it's so important to, friends of mine on the board of supervisors in San Francisco are going to kill me, but to annoy your city council people. I mean, just, the default is to give the police what they want. And if you have real concerns that what they want, is not only going to be invasive, it's going to be expensive, but also it's not going to work, it's not going to make people safer, then you have to go and tell your city council people that, because sometimes they actually really do listen. Sometimes going and talking to them can change their vote. And if it does, in San Francisco, December 2022, we got a policy that allowed the SFPD to use deadly force with robots fully reversed to become the nation's first ban on police deploying deadly force with robots. And we did that because people called. Like, a lot of people were really nervous about this issue and read up on it and read all the great stuff we were putting out and got involved. And so I think, being annoying to your local politicians is like one of the most important things you can do. And that's taking an active stance when it comes to safety. I think communities need to be involved. I think a lot of times technology papers over the chasm between the police and the policed. That police need cameras and they need microphones and they need all of this stuff because they don't trust witnesses anymore, because people won't call the police. And it's because of the mistrust that has been seen, rightfully sowed there over decades. And so I think active community involvement in safety and thinking about what your community needs to be safe is one of the more important parts of this.
Tracy, before I turn it back over to Lee Brokaw, any final word?
Yeah, two quick things. I mean, since I was given the history of surveillance part of this conversation, I'll just share that whenever a society has gone towards an authoritarian police state kind of form, and it's happened in many countries all over the world many times, the residents are always, you talk to people like, how did you let this happen? And it was always, well, we didn't really see it coming. So it's important to understand that as we give them all of these tools that could be used that way, we must take the responsibility for being engaged enough to make sure that it doesn't take that kind of turn, because it's really, really serious, and it could, and it always happens easier and faster than you think. That's sort of the lesson of history. And the other part is, whether it's an Oakland privacy in every town or an ACLU chapter or an EFA group, that's Electronic Frontier Alliance, is a part of EFF, whatever you want to call it, or make up a brand new name. Yes, we do need one in every town. I wish I could say that in Oakland, we were just kind of sitting around. We thought it was a great idea and a worthwhile activity. That's not what happened. We actually had a Department of Homeland Security port project drop on our heads that was then expanded into a surveillance gauntlet that covered the whole city. And we found out about it and panicked, and we had to do something. And then I guess we just forgot to disband at the end of that and kind of kept on going. So, but it was one of those things that was forced upon us, not one of those things that we just decided to do. But you guys, you sort of, everyone listening, you have the opportunity to be proactive and not wait until something really terrible is about to happen. And
well, it's been a pleasure just meeting you from afar, all four of you, and thank you again on behalf of the community for participating. And here's Lee, who is our local ACLU committee on these community concerns. And Lee, thanks for letting me play a part of this program, which I at least felt is terrific. So, balls to you.
It's interesting how you all got back to what I started in saying, is that after we have panels like this, we often form a committee to deal with these issues. And I'm playing with Peter, excuse me, I'm off script. I'm thinking maybe we want to call ourselves Santa Cruz policy readers. Those folks who are on this call, who want to be involved locally, as we have been urged to by every single panelist. My email is in the Q&A. Please contact me, and we will form a group and decide what part of this we're going to do. This is, by my count, the 8th time that PATCO, which is the acronym for our committee, has put on a presentation like this, from military weapons to sheriff's oversight to use of force to citizen oversight. And now here we are with surveillance and privacy. I want to thank those who came here. We got about a 50% turnout of those who registered, but the good news is that those who registered will receive a link to the recording of this program. We all will. And I want to thank the panelists who took 2 hours out of their night to be here with us. This conversation was way more than I ever thought it was going to be. And that's in the positive direction, of course. I want to thank the ACLU for the technical support. And above all, I want to thank Gary Patton, my friend, who graciously provided steady hand at the helm, steady hand at the tiller. I'm not sure everybody got their questions asked, but anybody who's still on the call, who's got questions that weren't asked, use my email, use me as a focal point. I'll pass them on to whomever you have asked Tracy about something. I'll pass the question on to Tracy with your email address, and the two of you can open a dialogue. I think everybody on this call is open to communication, and that is the key. So let's form Santa Cruz policy readers. I think that's Gary Patton's policy reading. That's what I'm taking away from this, aside from the fact that some very good friends of mine helped me in our PATCO group put this thing together. Thank you all very, very, very much.
Terrific job, everyone.
Thank you, everyone. Have a good night.
Thank you, everybody. Good to meet
Special
you all.
thanks,
Take care.
Tammy,
Special thanks to Tammy for helping
Thanks,
too.
Mike.
Really
We'll see
appreciate it.
you when you're in town.
All right, Lee, take care.
Okay.